Thank you for joining us on Salt and Pepper Unleashed. This ain't your grandma's nursing home. I'm pleased to be joined today by Bridget McDaniel, a member of the National Academy of Elder Law Attorneys and a practicing attorney with Williams, Barrett, and Wilkowski. She focuses in estate planning, which involves determining how an individual's assets will be preserved, managed, and distributed after death. Bridget, welcome to the show.
Thank you.
It is a pleasure to have you here. I do know estate planning and elder law can be such critical areas, especially as people navigate important decisions about their future. It's something that is absolutely imperative when folks make that decision to move to a community like Greenwood Village South. I also know that there are varying levels of preparedness, and I know that we have quite a few residents that have partnered with you and your firm prior to making that decision to move to Greenwood Village South, and others that I believe partner after the fact as they realize they do need some guidance. So just for the sake of our listeners, I really want to get into some of the details on what estate planning is and what it isn't. So let's start off with what would you say are the most common misconceptions about people that have estate planning and elder law in general?
Sure. Probably the most common thing that I hear is that I'm too young to need an estate plan, I'm too healthy to need an estate plan, or I'm not wealthy enough to need an estate plan. And I think those are the most common that I hear, and they're just completely wrong, because people don't understand what an estate plan is and what that means and the importance of the documents.
Yeah, too young. I mean, that's so subjective. I we were chatting about this before we started here, but the number that sticks out to me the most is 55% of folks over the age of 55 do not have estate planning completed, which is remarkably scary, if you ask me.
It is very scary. 55 is young, but also we all drive on the streets every day. Mm-hmm. We all, anything can happen. Mm-hmm. People get sick. Unfortunately, I've dealt with a lot of clients who've needed guardianships in their 40s because they didn't have any estate plan documents in place and different things like that. So, people, and even more unfortunately, estate administrations for folks that are very young. Yeah. So,
well, and I look at the too young as, well, if you have children, that kind of throws that. I would think that would be a great counter argument to I'm too young. Well,
absolutely.
That's a gift to your children, just having this planning completed. Healthy, like you said, well, you're driving on the road. Unfortunately, bad things can happen that are not in your control. And then not wealthy. I'm assuming there's probably some financial thresholds that are a lot less than what people would presume would be kind of the necessary level or threshold to have estate planning. Are there any financial guidelines in terms of your total assets of X amount than you absolutely should, or?
Not really, because the only purpose, saying where your assets go is not the only purpose of an estate plan. There are a lot of other reasons to have an estate plan, one of which is to ensure that you have proper powers of attorney in place. And I know here at Greenwood Village, that's very important to your residents, and that you guys always stress the importance of that with your own residents here. So that's, that has nothing to do with age. Mm-hmm. At any age, you could become incapacitated, whether it's temporarily or permanently, and need someone there to be able to help make financial or medical decisions for you. Mm-hmm. So that's really that. Now, the only real financial threshold would be in trying to plan to avoid the probate process in court at death. And that's $100,000 in Indiana. If you have assets over $100,000, you could end up in probate, and owning a home puts you right there.
Yeah, it does.
And you could not have a lot, not be a wealthy person, and have a modest home, and you're still well over $100,000.
And my understanding is that process really extends the timeline that would be otherwise to distribute those assets to the appropriate
Yes, quite
parties.
a bit. I mean, you're looking at 6 to 9 months minimum.
Wow.
Before you can distribute out the assets.
As opposed to what would it be otherwise if you have your estate planning in order?
In order, you could get liquid assets as quickly as getting a death certificate.
Wow.
Which is a few weeks.
Yeah.
And you could get a real estate upon filing of an affidavit, which could be done day 2, technically.
Wow.
So, you just, it's a lot.
So you're
it's
looking
a big difference.
at days and weeks compared to a half a year to a year.
Right.
That's crazy to think about the difference of just the intentional planning that goes into that. And again, that threshold is very different.
That's right.
But when we look at estate planning, estate planning is kind of the umbrella, if you will, in my mind. What documents are or should be included within kind of the planning umbrella of estate planning?
Sure. So generally, a sort of a basic estate plan is your will, describing how you want your assets to go, and even more importantly, who you want to be in control of that process, and who you want your children's guardian to be if you pass away, all these kind of issues. And that's one, but sometimes, again, even more importantly, is your general durable power of attorney, which is your financial power of attorney, so that if you cannot handle your day-to-day finances, somebody is named to do that for you. Without that, you would have to go to court and get a guardianship, which takes months. Again, and it's a real burden for your family to have to go through that guardianship process, and it's an expensive process.
I was just gonna say, there's an expense associated with going through the estate planning process, but I would venture to guess that expense is one, planned for, known, expected, but I would argue, with my limited knowledge, is significantly less than the expense that would be incurred when you have to go through the court and those various processes in order to get the powers and guardianships in line that are necessary. Is that an accurate
That is very
assumption?
accurate. I mean, it's thousands of dollars to get a basic guardianship that is uncontested by anyone.
Wow.
You have to have an attorney to do it. Indiana law requires that. You can't just go into court to try to get a guardianship for someone. So you're going to be paying an attorney some amount of money at some hourly rate for that work. And it's it can really build up. And I do guardianships. I wish I didn't have to.
Yeah.
I would rather get it, handled on the front end for much less for them.
Absolutely. Much less, financially, but also just the time, the stress, the emotional kind of turmoil that I would imagine comes along with that would be tremendous. So we've got will, we got general durable power of attorney. What else would there be?
And then generally you will have a healthcare directive. Sometimes that's done in 2 documents. Sometimes it's done in 1 document. My practice, I do it in 1 document. And that is where you name a person who will make medical decisions for you. Again, if you cannot make those for yourself. And then you can also express to your family and your doctors what your wishes are for life support, resuscitation, all those kinds of issues that come up toward end of life that make those decisions a lot easier for your family if they know what you want. So they're not saying, this is what I want for you. This is what they wanted, so this is what I'm going to do. And it takes that burden off.
In this industry, I have seen the absolute spectrum of what it looks like when someone's at end of life and they have gone through the entire planning process and have taken all the decision-making burden off of their loved ones, and just how peaceful that process can be. And then I've seen the opposite ugly end of the spectrum when no planning has been done. There's multiple family members involved in the decision-making. No one has been appointed as the decision maker. Everyone
Yes.
thinks that they are the decision maker,
Yes.
and it becomes so emotionally tumultuous that it breaks my heart to kind of watch that process unfold. And then I know that the closure is so much more fragmented and, I would say incomplete when that person does go than what it would be otherwise. And
Yes.
so I look at that and I'm like, I know for certain there's probably no price tag that those folks that experienced that tumultuous piece wouldn't have paid to not go through what they had to go through
Yes.
in that situation. And it's just shame to see that happen as often as it does, knowing that in this industry, everyone should have all these documents in order.
Yes. Yeah. And I mean, it really tears families apart sometimes because when someone's grieving, not necessarily because someone has passed, but even because if somebody's sick, grief and money don't really fit together very well. And so people act differently when it comes to these things. And in those emotional states really do that. And then after the person does pass, when there's not proper things in place to say who's going to handle this and make the decisions, you end up in litigation, which is very expensive. And then there goes your inheritance to lawyers. And nobody wants that to happen. And your parent,
Well, come on. There's at least one of us on this show. I'm just kidding. I'm joking. No, you and your entire team that I've worked with have been an absolute pleasure. And, there are so many lawyer jokes that I could tell that I've heard over the years. But you and your team do a great job of breaking those stereotypes and really serving the clients to, what their needs are. So I'm very appreciative of that, knowing that we can have partners that, I can trust that our residents are getting the type of care and service that I would want for myself or any loved one. But let me ask this. So I'll be 40 this year. Wife and I have three young children, 9, 9, and 10. We've talked about estate planning a lot over the years. We've not done it.
Yeah.
Let's say we do it. Age 40, kids, 3 in the 10-year-old range. How often should we kind of take a look at that and review it and update it?
Sure. We generally say at least take a peek at your estate plan every 5 years. Doesn't necessarily mean you need to go back into the attorney, but take a peek at it. Look at the people you've named as your representatives. As your children become adults, it'll probably change to them as opposed to other folks. And so you really want to take a look at that. And while they're minors, you'll want to keep track of who you've named as guardian and how their life is going.
Yeah.
Because that can be very important as well, to say, oh, man, now they have a bunch of kids and they didn't when we named them, and that's going to be a real burden on them. So maybe we should find another person, and all those kind of things. So we say, take a look at it about every 5 years or so to make sure that it still meets your needs.
Well, so there's kind of that timing piece of it, but I would imagine there are life events that kind of trigger a change as well. So for instance, if it's, we identify, this person as the guardian and they end up moving across country 2 years later, they're probably not going to be the best choice to be the guardian. And so just that move in their life, I would think would trigger, well, let's take a look at this. Do you see that? And I guess you probably see it, but I have a feeling people aren't nearly as proactive with making those changes as they should be. Like I'm not nearly as proactive as I should be. So
yeah, I think people don't think about it.
Yeah.
People don't think about it. Nobody wants to think about
that's
estate planning. Nobody wants to think about dying. Mm-hmm. And I get it. Nobody wants to think about being incapacitated. Mm-hmm. It's not fun stuff to deal with, but it is very, very important. But because it can become a real problem. And so, those certain life events, again, like your children becoming, reaching the age of majority, that can be a really big deal. If disabilities happen, very important to get planning done for that. So there are lots of variables in your life that can.
And I look at it too, and just the people in my life that I know, and even my relationships with the people closest to me, I know I've had conversations about what that looks like, but I also know for certain that would not remove the burden of the decision making with it not being formally executed in this manner.
Yeah.
Saying this is how I would want to go when it's my time. Just saying that, even if I say that once a week for my entire life, it comes to that point that doesn't really hold any water until you actually see that, written out in front of you, and it kind of takes that emotional burden off that decision. So, switching gears just a little bit here and moving more towards kind of the financial piece of things. What are some ways that people can look to avoid, if possible, but minimize estate taxes when that time comes?
Sure. This is getting back to the misconceptions question. There's a lot of people assume there are a lot of taxes that come into play when you inherit money. Right now, under the current state of the law, these things change, but the current federal estate tax exemption is $13,910,000 per person. So for a married couple, you're looking at almost $28 million. As long as your estate's under that, which most of us fall well under that, you're not looking at estate taxes at all. Indiana got rid of our inheritance tax in 2013. So there are no death taxes at a state level for residents of Indiana. So generally, we're not planning around estate taxes. We have a few. You find them from time to time.
I'd have to do a quick tabulation, but I don't think I'm there yet either.
Most of us aren't.
Okay, tabulation complete. Not there.
Yeah. So it's not really a big issue.
Yeah.
If it is, there are some things that can be done, but it's really complex planning at that point that it just isn't done very often.
Yeah.
It's just not needed anymore.
So you mentioned at the state level. Is there any considerations at the federal level?
That's the 28 or the 14, almost 14 million is the federal.
Okay,
estate
that's
tax
the federal.
exemption.
You're saying there is no state considerations as
At
of
all.
2013. Okay.
Right.
Okay. So I would imagine it's few and far between that hit that threshold, and so not really something to be concerned with. So really, when it comes to dissolving the estate, until you get to that point, really the only expense associated is with the expenses associated with the planning and executing of that plan.
Correct.
Not necessarily any taxation on distributions, anything like that.
Right.
Okay.
Because inheritances are not taxed as income to a person at all.
Okay.
Not that I'm an accountant, because I'm not.
Yeah. Oh, yeah. You always got to throw that one out there. I agree with that. So help me understand the difference between a will and a trust, because again, I have a feeling there's a lot of misconceptions around those two, and people changing those when they probably shouldn't. So what's the difference?
Sure. So a will is a document that you say how you want your property to go, who you want the guardian of your children to be, who you want your personal representative to be. That's the person who handles your estate. A trust does similar things. A trust is a document where you will describe how you want your assets to be distributed. The purpose of a trust is to avoid your assets going through the will, because when assets pass through your will, they are probate assets. And so again, if you meet that $100,000 threshold, then you might end up in probate. There are other ways to plan around that as well without a trust, but that is the sole purpose really of a trust. A standalone living trust is what we usually call those. You form it while you're alive. you title your assets into the name of the trust, so they're all owned by the trust. And then at your death, the trustee, instead of the personal representative, will distribute those. So you're avoiding a probate process if you have those assets in a trust.
Okay. So really, these are a lot of the vehicles that we talk about are to prevent an extended timeline of distribution and resolution, if you will.
Right. Yeah. There's still a trust administration process, and the trust will have a tax return generally. So it takes a little time, and there's a little expense, but not nearly the expense and the time of a probate administration.
Yeah. Okay. So then you hear the terms revocable, irrevocable when it comes to trust. Help me understand the difference between those two.
Sure. So the revocable trust is that revocable living trust that people often do with their estate plans. And like I said, the only purpose of that trust is really to avoid probate. And so then and this is actually a big one of those misconceptions as well, is we should just put our assets into an irrevocable trust. Well, irrevocable trusts cannot be changed. They're irrevocable. You can't amend them. You can't do anything with them. And once your assets are in there, they're in there. And they're not yours anymore. And so you can't use them anymore. And so that's, something to take into account when people think about that. The most common time I have people asking me about irrevocable trusts is to protect assets from expenses of long-term care, right? And so because there's a 5-year period of time, if you're going to get assistance to pay for long-term care, that they look back to see if you've made any gifts. Well, once you have assets in an irrevocable trust for 5 years, they no longer count toward any type of means-based programs, such as Medicaid. And so, people find that attractive. But also you have to think again, once they're in there, they're not yours anymore. And you can't get them back. And so if you decide, that if you live to be 90 and don't need long-term care and you want your assets,
probably not the best.
Kind of too bad.
Yeah.
At that point. And so it's a tough thing to do.
Well, but you guys, don't you have the crystal ball at your office?
Yeah, we try.
You just rub it and say, well, this is what it's going to look like.
This
and then
is
everyone knows
exactly
what to do. Yeah. Oh, man, I thought you had one of those.
Yeah, we're working on it.
Okay. Well, let me know because I have a feeling we're both going to be doing something different if we get that code cracked. Okay, so irrevocable is essentially they're not your assets anymore.
Right.
You're indicating how they'll be utilized, distributed, at whatever time, but they're no longer yours.
Right.
But until those assets are put into that irrevocable trust, they're still in that look back period.
Correct.
For government to determine, participation in a needs-based program.
Correct.
Okay. That's good to know. Very good to know because I think people throw that one around probably way more than they should. Is that what you see in your practice? People are like, let's throw it in an irrevocable trust.
Yes, I hear it all the time. I'm like,
Let's-
okay, why do you want to do that?
Yeah.
Let's talk. And so we go through the pros and the cons, and sometimes people use them and sometimes people don't.
Do you typically see the vast majority of folks that once you kind of walk through that process and there's a logical approach, either one to the irrevocable trust or two, them changing their mind to a revocable trust. But do you see people going against the grain and you're like, I still do not recommend that, but they go that route anyway?
Yes.
Really?
Yes. It happens not very often. Yeah. Usually once you explain to them exactly what they look like, they will make the right decision that fits their asset picture. And usually, if they're coming to us, we have a relationship and they're trusting our advice and what we're telling them.
Yeah. I would just be so interested to understand the why people would go against the grain after knowing, all the details to it. But
a lot of people have Google JDs, a Google law degree.
Oh, yes. It's like WebMD, right?
Right.
But for lawyers.
But for lawyers, yeah.
Absolutely. All right. So if a person dies without an estate plan, what happens to their assets? We kind of talked about this. It's a couple different. Really, that 100,000 threshold is kind of dependent on what happens.
Correct.
So what happens under that $100,000 threshold, and what happens above and beyond that $100,000 threshold when someone passes with no estate plan?
Mm-hmm. So if you don't have an estate plan, there is a distribution structure that is laid out in Indiana law. It describes how much goes to a spouse, how much goes to your children, how that's all laid out. If you don't have children or a spouse, how that
if I recall,
sort of out the family tree.
I have seen this before, and it gets pretty deep, doesn't it?
It does. It gets very deep.
Yeah.
Because things happen.
Yeah, and it's like you can get like significantly removed from the individual, and if it's like the litmus test of the next step. And if
Right.
it doesn't hit, then it goes to the next. But I recall it goes very, very deep.
Very deep.
What's the kind of most obscure relationship on that kind of decision tree?
Oh, goodness. I mean, it would be, cousins, third cousins twice removed
But I
or
think I
something.
even remember like there's even no relation, isn't there? Isn't there
It only deals with family.
I don't want to say friends, but I thought there was somewhere on there that
At some
I'm like,
point,
that
it
doesn't
will go to
seem
the
like-
state.
Okay.
At some point, it will go to the state if you have literally no family, no matter how
kidding.
far removed. Society has changed so much. It's happening more and more that people are older and maybe never got married, or maybe they got married but never had any children, and they don't have siblings. And it's becoming more common with the families kind of being smaller.
Yeah.
It's tough sometimes, and we have to employ air search services, literally searching for anybody that could be related to a person, so that we can do that. Like when you see in a movie when somebody gets a letter from some lawyer about some
Yeah.
uncle that died, right? It can turn into that.
I still haven't got one of those.
Yeah.
Still waiting on it.
Me too.
Yeah.
The biggest one though, that when you die without a will, that people don't realize, and again, it comes with a change in society, and that is husbands and wives nowadays own things separately sometimes, and it really didn't happen in previous generations a whole lot.
Happens a
but
lot
it happens
now.
a lot
Yeah.
now. And especially if you get into second marriages or anything, any kind of those kind of circumstances, when a husband if a husband passes away and he has a wife and he has children and he has no will, his wife gets half of it and his children do. And a lot of people don't realize that. They think that everything just goes to the spouse. It doesn't.
And I bet that causes some turmoil.
Sure does.
Yeah.
It sure does, especially in a second marriage situation or, subsequent marriage.
Well, I'm sure, and that's also dependent yet even more on the relationship with
Right.
the children and that second
parent.
spouse, either way.
Yes.
Yeah. Oh, boy. Those
yeah.
are some conversations that I'm happy that I'm not a part of.
Right. And in our firm, we have several litigators in our firm. I don't do that side of it.
Yeah.
I try to prevent it with my
Yeah,
documents.
absolutely.
But if it does come to that, we have litigators, and we do a lot of estate litigation.
No kidding.
And so we see all of these sad situations where these things happen. So, getting a will, and trust me, getting a will is infinitely cheaper.
Yeah. Well,
than
and in that
litigation.
situation, you say these sad situations. I would assume that there's probably a reality TV show out there somewhere that could be made
Oh, yeah.
based off of kind of the turmoil that's evoked with these. But at the end of the day, they are sad situations because when you think about the individual that passed,
Right.
for certain that is the last thing that they would have wanted to happen
Right.
in their passing. And here it is in this kind of just ball of dust and, chaos. And so as entertaining as it is on the outside looking in, it truly is a sad scenario when that happens, I would imagine.
It is. And even when there isn't turmoil, I mean, just as by way of example, we had someone who passed and he was in his 30s. He was married and had small children. And so now the surviving spouse owns all of their assets, their home and all of their assets with her children, which is fine. She's their mother, but now she has a fiduciary duty as their guardian, to actually make sure that that is their asset and not her asset. And it's different, and that's just a difficult thing to deal with, even though there's no, conflict between she and her small children. It's still an awkward situation, and so. But
are the 50% of the assets that are split between the children? Is that in perpetuity? Is that forever? Is there a way to kind of reallocate those assets back to the mother? Because I'm thinking, so then what happens when they're no longer children and they turn 18? What happens then in those situations?
Those are their assets at that point.
No kidding. So there's no way.
They can give them back to her.
Okay.
If they want to.
But even that's a sticky situation.
It can be.
Hey, sweetie, I've got a big favor to ask.
Right. I'm going to need you to sign this deed.
Yeah. And then as the guardian, I mean, she's the responsible party, but in that situation, I wouldn't imagine that would hold any water that you got an 8-year-old signing.
Right. You'd have to wait until they turned 18.
Oh, my goodness.
Or get a third-party guardian appointed or something. Wow. In order to be safe in that instance, I would always say, let's have a judge make this decision.
Yes.
Just for your protection. You don't want, because you never know. I mean, family dynamics change.
They do.
And if, a child gets into something they shouldn't and ends up, estranged from the family, no way are they giving their interest back.
Yeah.
And it unfortunately happens. And so, it's just so much easier just to have your will in place, even if you're young, because, again, we just don't know what can happen. Also, just kind of as a side note, having your advance directives when you're young is extremely important. And I talk a lot to clients who have children in college. And I say, but they're adults. So if they become incapacitated, even if it's temporarily, they're in the hospital, that hospital may not talk to you. Yeah. All those things, because they are adults. Just, we might not see that 18-year-old as an adult. They may be in high school.
They're still your little baby, but
they're adults. Yeah. And so I encourage folks when their kids turn 18, get some advance directives in place to make sure that you can handle the things for them that need to be handled. Also, if you're paying for college, that doesn't give you a right to see their grades.
Yeah. Yeah, there's a lot of misconceptions there.
And so, again, having some documentation in place can really be important for those situations as well.
Is there documentation that if I pay for my children's college, I can see their grades?
No.
Can you help me with that?
It's a federal waiver that your child would have, adult child would have to sign, allowing you access to their records.
All right, I'm gonna have that one on file and ready to go when they turn 18.
Yes.
So all right. So one more on kind of the same topic, and then I've got two last kind of final questions for you. What about in the event of incapacity? How can someone be sure that their wishes are followed when they are incapacitated? Is that kind of what we just talked about there?
Right. So that's having your general durable power of attorney in place and your healthcare directive in place, so you know at least who you've entrusted with those decisions. And then that person, usually the concern is with money, making sure that they do with your assets what you would want them to do, not what they want to do. They cannot use the assets for their own benefit. If they do, they can get in a lot of trouble. It's criminally punishable because they have a fiduciary duty to you. You have a right to ask them for an accounting for everything they've done. All of your heirs have a right to ask your power of attorney for an accounting. And so they have to follow a line. or they're supposed to follow a line. I mean, it really is a serious thing. And another real common question I get asked with a power of attorney is, am I personally responsible for any of this person's finances? And that's a no. You're not their guardian. You are not their parent. You're just power of attorney. It's an authority document. You don't even have to act on it at all if you don't want to. You can't be forced to do it. So
But then as a guardian, you can be forced, right?
Yes, as a guardian, you are forced. It is as if you're really like a parent
absolutely.
to that person.
Okay. Here at Greenwood Village South, we have amazing residents with amazing families. 99.9% of the time, but even I have experienced a specific situation very similar to what you just indicated, where it was a resident who was incapacitated and an adult child who was not acting in their best interest, and it was quite the process to kind of go through and kind of regain control of the situation in order to provide the appropriate care and make the necessary decisions for that resident based off of what we knew their wishes to be prior to the adult child coming into play. And unfortunately, in that situation, it seemed and the judicial system turned out to agree with us that the actions were financially driven and self-serving for that adult child, and I'm just happy to know that we were able to make it through that process and help the resident kind of regain that control that was necessary. But even in a community like Greenwood Village South, where the culture is so family oriented and so warm and so loving, it still can happen, and it just takes that one bad egg that really is just kind of that self-serving individual that can really they can kill the mood.
Yes,
to
they
say
can.
To say the least.
We see more of it than I wish we did.
I bet.
Yeah.
All right. So last question before our signature question. I'm curious. So we here at Greenwood Village South have a philanthropic platform called Living Tree Legacy, and it's an opportunity for residents to give and kind of leave a legacy, give in financial terms. How can a monetary gift be left to a charitable organization of any kind, but specifically Living Tree Legacy in the event of their passing and those assets being distributed?
Sure. So if you have a will or a trust, you can designate a dollar amount to that charity. You can designate a percentage of your estate to the charity. You could also, really common with a lot of folks, is they will give a portion of an IRA. It's a really easy way to do that. And of course, the organization then won't be taxed.
Yeah.
So instead of taking it out of your estate, which is going to go tax-free to your children or whoever, sometimes it's better if you're going to give a charitable as well to do that from the IRA, because your children will be taxed when that money comes out of the IRA. The charity will not, because they're tax exempt.
And you're speaking of traditional RRAs.
Traditional, of course,
Correct.
yeah, if they're tax deferred. Mm-hmm.
Okay, very good. So just simply.
And life insurance, kind of same thing. Just name them as a beneficiary of either a percentage or all of it.
Okay, so very simple process. People just have to indicate their wishes, essentially. Yes. Okay, very good. Well, Bridget, this has been great. This is information where I'm exposed to it on a regular basis, but until you really get into the nitty gritty and start having those conversations, you don't know how much you don't know until you talk about it. And so I've been enlightened just through this conversation, even though that we've worked together multiple times in multiple scenarios. I've learned so much just here, so I hope our viewers have too, and hopefully the message for those folks that are 55 and older, if you're in that 55% that don't have estate planning done, then you need to get to it And then to my peers out there in their 30s and 40s, if you've got children, better get to it as well.
Right.
So you might be getting a personal phone call from me at the office here sooner than later. So we end our shows with our signature question. Has turned to be my favorite question. I want to know, if you could be remembered for one thing, what would it be and why?
That's a tough question because there are so many things. But I will say this, and I love my job. Mm-hmm. I love working with seniors. It's a passion of mine, and I've done other areas of law as well, still do some other things, but this is really my focus, the elder law and the estate planning, because I do want to be remembered as doing something that actually does help people through tough decisions and planning for tough things.
Yeah, absolutely.
It's really hard for families to do these things, and just having some really basic work done by an attorney can really make things easier. And so if I had to be remembered, I would hope that people would remember that I helped them. Yeah. That this person was really helpful during a difficult time.
Yeah, that kind of that North Star, if you will.
Yeah.
And I would say the benefit that people experience, not even consciously.
Right.
Because you realize the lack of benefit when you don't have those conversations. Yeah. But unfortunately, I think it's probably hard to really grasp the gravity of the benefit once you go through that situation, because you've done the planning. Right. And so it's hard to wrap your head around that. But just seeing it from both ends of the spectrum and everywhere in between, I would say what you do is absolutely commendable and has made a lot of lives a lot better and more enriched, especially in a really tough time. So I thank you very much for what you do, and I know our residents do too.
Yeah, and same, because I know you guys do a lot of wonderful things for people that are dealing with difficult times as well.
Absolutely. So, well, Bridget, again, thank you so much for coming on the show. And like I said, you'll probably be hearing from me soon.
All right. Sounds great.
Thanks.
Thank you.